Hi, my name's Claire of ABC Paralegal, and this video is about 5 mistakes litigants in person make in family court. Many litigants in person walk into family court believing that if they tell their story clearly, the court will understand their position. But in reality, cases are often damaged not by facts, but how those facts are presented. In this video, we're going to talk about 5 common mistakes in person that people make in family court and how to avoid them. In England and Wales, family cases are governed by the Children Act 1989 and the Family Procedurals 2010. The court's focus is always on the welfare of the child, but how you present your case still matters. Mistake number 1, focusing on emotion instead of evidence. Many litigants in person focus on personal grievances rather than evidence. For example, criticising the other parent, raising historical arguments and making general accusations. The court are not there to resolve personal issues, they're there to determine what's best for the child. Judges look for evidence, consistency and relevance. For example, historical allegations. If it wasn't relevant 5-10 years ago, then why is it suddenly relevant now? And that's not to say it shouldn't be raised, but that's a perspective you have to look at it from. Mistake number 2, interrupting or challenging the judge improperly. Courtroom behaviour matters, and overall it just shows politeness and etiquette. Interrupting the judge or speaking over others can quickly damage your credibility. Even if you strongly disagree with something that's being said, the correct approach to it is wait your turn, respond calmly and focus on evidence rather than emotion. Mistake number 3, poor organisation of evidence. Another common mistake is disorganised evidence. If you cannot quickly locate the documents when asked, the court may not consider them effectively. Good practice includes organising the documents chronologically, using page numbers, preparing a simple index, and there's nothing to stop you organising a bundle in preparation for your hearing. Now, the worst thing that you can do is arrive at court with 20 pieces of evidence that you want to rely on, because that's not the correct way to do it. There is a process, and you have to ensure that that process is followed if you want that evidence submitted. Mistake number 4, misunderstanding cross-examination. Cross-examination is often misunderstood. Its purpose is not to argue, it's to test the evidence. It's to show flaws in your evidence. It's to show inconsistencies in evidence. So instead of saying you're lying, you should ask something like, in your statement, you said this, is that correct? This allows the court to identify the inconsistencies. Another example could be, you allege this, however you fail to inform anyone, NHS, police, etc., but yet you feel it's relevant for the court. Why? Mistake number 5, not understanding the purpose of the hearing. Different hearings serve different purposes. So, for example, FEDRA, First Hearing Dispute Resolution Appointment, that essentially identifies the issues, it explores any agreements, and it is essentially where do we go from here type of hearing. Fact finding, determining disputed facts. This is the hearing that will address any allegations, whether one person has raised them or whether there's cross allegations. Dispute resolution appointment is where the court try and find some resolution to the issues, and then your final hearing is where the decisions are made. Before we finish, I just want to talk about how important it is to understand how these mistakes actually play out in real hearings, because in many cases it's not legal argument that determines how a case progresses, it's how the argument is presented. So for example, in one scenario, a parent spends most of their time criticising or denigrating the other parent's behaviour. They raise multiple complaints, but provide very little supporting evidence. And the judge does listen, but ultimately redirects the discussion back to the child's welfare, because that's what the court's main focus is on. As a result, much of what you have just said carries very little weight. And in essence as well, you're also, by exaggerating the small things, you're taking away your own time to discuss the more important factors. Example number 2, disorganised evidence. In another situation, a litigant refers to an important message or document but struggles to find them when the judge is asked, or doesn't present them formally as evidence. The hearing will continue and the opportunity to rely on that evidence can be effectively lost. In contrast, a well-organised statement or bundle allows the court to immediately consider that relevant material. Example number 3, poor cross-examination. In some hearings, litigants in person attempt to challenge the other party by making direct accusations. For example, you're lying about this. Well, that's not a question, that's a statement. But that doesn't help the court. A more effective approach is questions that highlight the inconsistencies, and without structure, the point may not properly be established. So, for example, are you attempting to mislead the court on this allegation? That is separate from saying you are lying about this. Example number 4, courtroom behaviour. There's also cases where a litigant becomes so frustrated and interrupts the judge and speaks over the other party that even when their concerns are valid, this behaviour can affect how their evidence is received. The judges, well, people in general within that courtroom expect proceedings to remain respectful. Misunderstanding the hearing. Finally, it's common for litigants in person to approach an early hearing as though it's the final decision. This is surprisingly quite common. They'll try to argue the entire case. They'll put points forward that aren't relevant for that hearing, rather than focusing on the purpose of that at that stage, which may simply be about identifying issues or setting directions. And the key takeaway from all of this is family court, it's not just about what you say, it's how you say it. Understanding the process and focusing on the evidence and approach the hearing in a clear, organised way can make a significant difference to how your case is received. My name's Claire, thank you for watching. Like and subscribe for more content.